Good morning. My name is Malcolm Neekirk. This morning I will be talking about remuneration with particular reference to the rules in bankruptcies. Now, the scenarios that I'm interested in covering, the most common one is going to be where you have just been appointed as trustee in bankruptcy and you need to set your remuneration for the first time for the duration of the bankruptcy. And of course, that's the common situation. I'll also be looking at the cases where there's perhaps an established bankruptcy, but you are looking at changing the basis for your remuneration, either retrospectively, so that the new arrangements will take effect right from the outset of the bankruptcy, or a change in direction from this point so that the new arrangements operate only from this point onwards. And in particular, I'm going to be looking at the rules about remuneration in Part 18 of the insolvency rules. Now, those provisions cover administrations, bankruptcies, and the 3 liquidation procedures. And by the 3 liquidation procedures, I mean, of course, compulsory liquidations, creditors' voluntary liquidations, and members' voluntary liquidations. And if you've heard me talking before about the way that liquidations are dealt with in the 2016 rules, you'll know that I'm very much in favour of the way that they have been drafted so as to treat those 3 different types of liquidations as very much their own separate and distinct procedure, where they don't have much in common other than the fact that each of them is described as a liquidation. And also just to mention that I will be focusing very much on the insolvency rules this morning, but I won't be covering fee estimates. If you think that would be a useful topic to cover on another day, please let me know and I can add it to the list. So in terms of the topics I will actually be covering today, I'll be looking at the 3 bases for setting remuneration. I'll be looking at who it is who makes the decision about which of those bases will apply. I'll be looking at the default setting in bankruptcies and looking at the procedure that you should follow to set the basis for your remuneration if it is the first time that it's being done in the bankruptcy, if this is where it's a new bankruptcy for you. And I'll also be looking at the arrangements where you are looking to change it later, and the 2 alternatives there of when you're looking to change it for the whole bankruptcy, so it is effectively a retrospective change that goes back to the start of your appointment, and those situations where you're looking to change it, but only from the point where it is changed. So you'll have one basis for your remuneration up to a particular date, and then from that date you'll have a different basis for your remuneration. And the final point I want to cover is just to look briefly at the other procedures dealt with in Part 18 of the insolvency rules to see what is different about bankruptcy from those other procedures. So let's start by looking at what the 3 bases are. Very familiar territory this will be. There are 3 options that you can choose from. You can work on a percentage basis, you can work on fixed fees, or you can work on time costs, and you are expressly permitted by the insolvency rules to mix and match, to use a combination of 2 or even all 3 of those. Now, when you're going for the ad valorem basis for your remuneration, when you're going to be working on a percentage basis, you can simply adopt the statutory scale rates, which are set for the work done by the official receiver, and they of course include 1% for the value of the assets that you realise, and a 2% for the value of the assets that you then distribute to creditors. But you're not confined to working on official receiver scale rates. You can set any other scale rates that you choose, and they may be exclusively a realization basis, or they may be exclusively a distribution basis, or they may be two bases. It's up to you what you want to propose. If it is fixed fees that you want to work from, then you can propose a fixed fee for the whole case, or you can propose a fixed fee for just certain specific parts of the case. So, for example, you might think that it's sensible to work on fixed fees for the statutory compliance work that you're going to have to do on the case. And similarly, if working on time costs, you've got the option of asking for time costs for the whole case or just for specific parts of the case. So there may be some parts of the case where it is very, very hard to assess how much work you're going to be doing, and it may be fairest then simply to go for time costs for that. So those are the three options, and you can choose any one or more of those options. In terms of other things to think about when you're setting the options, when you're asking for a percentage, an ad valorem basis for your fees, then you have to propose not only that as the principle, but you also have to set the percentage that you're going to apply at the same time. And similarly, when asking for fixed fees as the basis, you don't just ask for fixed fees, but you also ask for the amount that you wish to charge to be set at the same time. And when you're working on time costs, then of course asking for time costs will trigger the rules on fee estimates. And you have to say not only what you think the work will cost, but you will also have to say what work you think that you will do. And I'm not going to say much about SIP 9 this morning, but I'll just mention it here, which is to say that if you're not asking for time costs, then you have to explain why you think that working on a percentage or a fixed fee is fair and reasonable. And I think a lot of practitioners take the view that that therefore implies that you ought to be giving a comparison as to how much you think you would be charging on time costs if you were going to be doing the work on a percentage or a fixed fee basis, just to ensure that creditors are properly informed. And on this page, I've listed the statutory factors that have to inform the decision about which basis you wish to adopt for the case. These are factors that probably you don't give a huge amount of thought to at the time of asking for the basis for your fees, but they are the ones that the rules say you should be basing your decision on, and the creditors should be basing their decision on. And if ever you find yourself having to go to court with a dispute about your fees, then these are the factors that the court will look at to see whether the basis and the quantum are fair and reasonable. So the first of those is the complexity of the case. The second one is whether there is any exceptional responsibility arising from the bankrupt's affairs. Now, the word exceptional is important there, and it means that it's only in a very small proportion of all bankruptcy cases that you will be able to argue that you are accepting any exceptional responsibility, because by the nature of the world, in most bankruptcies you will be accepting routine responsibility, and it's only a minority of cases where the responsibility will be exceptional. The third factor is how effectively you are doing the work. And that's difficult because, of course, when you are proposing a particular basis for remuneration, you don't know how effectively you're going to be doing the work, and to some extent it may be outside your control how effectively you end up having done the work, just because of the degree of obstruction and difficulty that you may have to contend with. So I don't really see how the effectiveness of your work can be assessed in advance. There may be some assumptions that you put into your fee estimate, for example, as a way of doing that, in which case if those assumptions turn out not to be true, then that may affect how much you are then able to charge as the amount under the basis that has been adopted. And the final factor to be taken into account is the value and the nature of the property. Now, nature of the property, I suspect, is probably going to feed back into the other factors of complexity, perhaps exceptional responsibility, and perhaps the effectiveness of your work. Value, to some extent, will also perhaps feed back into the effectiveness of your work. But I think there's a clear signal there that in cases where there is significant value in the estate, then you should be entitled to be remunerated on a more generous basis than you might on a more routine bankruptcy. And there are also factors that are identified in SIP 9 as ones that you should take into account. These are not statutory factors, they're not legal factors, they're more practical factors in terms of the experience of the profession as a whole about what it is that creditors tend to kick off about when they're not happy with the fees that are being charged. And the factors basically boil down to what work are you doing and why are you doing it? How much are you actually going to be paid in terms of the quantum that you receive, the amount that you receive as your remuneration, and what benefit the creditors are going to receive from the work that's being done. And there are two measures of that benefit. The first one is direct benefit to creditors, and this then translates pretty directly, I think, to how much are you recovering for them. And the second one is work that you have to do simply by virtue of the statutory nature of your appointment, compliance and other work that the creditors, if asked, might prefer that you don't do, but you don't have a choice about it. You have to do it just as part of your appointment. So that's looking at what the bases are. So let's look at who sets the basis. And this will be in a bankruptcy where you've just been appointed, and at this point there has been no discussion about how you should be remunerated for the work that you're doing. So there are three bodies that you can go to ask them to set the basis. The place to start, if you have a committee, is of course the committee. If you don't have a committee, or if you've asked the committee to make a decision and they've not made a decision, or if you've asked the committee to make a decision and you don't like the decision that they've come to, you can then go to the creditors as a whole and ask them to set the basis for your remuneration. If you're asking the creditors to set your remuneration, it has to be by a decision procedure. I mean, that always applies to remuneration in any procedure. You cannot use deemed consent to get your remuneration approved. It has to be a decision procedure. And your third option is to go to the court. If you've been to the committee and the creditors, then you can, I think, go to the court within the first 18 months after your appointment. If you haven't been to the committee or the creditors, then it's going to be difficult to go to court until 18 months have gone by. You might be able to do it in some unusual circumstances, but the judge is going to ask what the creditors think, and if you haven't asked them, why you haven't asked them, particularly if you're applying within the first 18 months. And the other option that you've got is if you're happy with the official receiver's statutory scale rates, you can simply decide not to ask for any other basis and the scale rates will automatically apply. Which brings me tidily on to the next topic, which is the default setting for remuneration in bankruptcies. And yes, the official receiver's scale rates are the default setting. They will apply automatically after 18 months if you have not asked the creditors or the committee to set a different basis for your remuneration. They will apply earlier than that if you have asked the creditors for a different basis and the creditors have refused to set the basis that you've asked for. They might, statutory scale rates might also apply in cases where you perhaps asked for a different basis from the committee. The committee said no, and you decided that you wouldn't then go to the creditors, and your decision not to go to the creditors might be because you'd already got creditors representing more than 50% of the creditors on the committee anyway, so you wouldn't expect the creditors to make a different decision. And in a case like that, I think you could probably just report to the creditors that this is what's happened. You asked for time costs, you didn't get time costs from the committee. In the circumstances, you are prepared to work on official receiver scale rates, and you will be treating that as effective immediately. I think you could do that. So the procedure for setting the basis, this is really covering again what I've already said. You start with the committee if you've got one. If you don't have a committee, or if the committee says no, you've got the option of going to the creditors. And you've also got the option of going to the court if there is no committee and if the creditors are not interested, or if there is an obstructive committee, obstructive creditors, or you can simply just keep your head down, wait for 18 months to go by, and then once scale rates have been set as the basis, you can then apply to the court to ask for that to be changed. But as always, if you apply to the court, the judge is going to want to know what the creditors think, and if the creditors haven't been asked, the judge is going to want to give the creditors a chance to express their opinion. And remember also that if you're asking for time costs, you have to give a fee estimate, and if you're not asking for time costs, you have to give good information to creditors if asking for something else, and I think that would often imply a fee estimate. Of course, that doesn't apply if you're just going to sit on your hands and let official receiver scale rates kick in. So let's look at what you do if you have got a decision about what basis for remuneration should apply, but you then decide that actually that's not appropriate for the bankruptcy as a whole. And the scenarios when you might want to do that is if the rate or the amount is too low, and that would be if you're working on a percentage or fixed fee basis, or if the basis is not appropriate, which would be for any of the bases that have been set. And this is effectively an appeal procedure that you are running here. So if it was the committee that set it and you want to change it, you can ask the creditors to change it. That's essentially an appeal from the decision of the committee. And if the creditors refuse, you can then go to court. If it was the creditors who set it, then you can call another creditor's decision procedure effectively to ask them to review their earlier decision. And if they still don't change their mind, then you've got the right of going to court. And if it was a case where it was the court that originally set it, you can ask the court to change it. But this, again, is probably going to be in the nature of an appeal. So you're probably going to find yourself having to go to a higher court, such as the Court of Appeal or even the Supreme Court. And it's unlikely to be successful as a generalization. Judges have got tremendously broad discretion when it comes to setting fees and remuneration, and it'll be a very difficult decision to appeal. Let's look at the other situation, which is where the bankruptcy is changing direction, and you think that what you agreed at the outset is no longer going to be appropriate. You're happy for that basis to remain for the work that you've done so far, but for the future, you want to have a different basis for doing so. And so this is a slightly different procedure here, where you are asking effectively for the basis for your remuneration to be reset, but only from the date of the new decision about it. So when you're likely to do this is where you've actually got a basis set that you asked for, but something has now changed, so it's not appropriate for the future work. The rules should only kick in where you can show that there is a material and substantial change in circumstances that means that you're justified in asking for a different basis for future work. And here, if it was the committee that set it in the first place, because it's now completely different, you're not appealing against their decision, you're basically asking them to make the same decision but on different facts. You can go back to the committee again, you should go back to the committee again to ask them to change it. And if you can't get a decision from them, you effectively can appeal from their decision or lack of decision to the creditors. And beyond that, appeal to the court. Similarly, if it was the creditors who set it originally, you go back to them to say, look, things are different now. For the future, I want it to be different. Will you agree? It's not an appeal against the decision they made previously. It's now something is different, so we need to do something different from this point. So the creditors can agree to change it, and if they refuse, you can go to court. And if it was the court who originally set it, you can go back to the court to ask them to make the change. And again, in this case, because you're not appealing from the decision of the court, you're asking them to make the same decision on different facts. You would start with the same fact, the same court. And in theory, you've got the right to appeal to a higher court. In practice, unlikely to be successful. So let's look now at what's different in other procedures. And I just want to emphasize that this is just the headline about what's different. It's not all of the differences. So the first thing that's different is that statutory scale rates apply automatically in compulsory liquidations and bankruptcies, but only in compulsory liquidations and bankruptcies. Scale rates do not apply automatically in administrations or voluntary liquidations. In voluntary liquidations and administrations, you effectively have an 18-month deadline to set the basis. So you have to set the basis for your remuneration within the first 18 months after you are appointed. What happens if you miss that deadline? Well, you can still ask the committee or the creditors to agree the basis for your remuneration, and they are still competent to do that. The difficulty that you've got is that your negotiating position is very much weaker because you will have missed the deadline for applying to court. So if you don't like the decision that the creditors are prepared to agree to, you've got nowhere else to go. Doesn't matter how unreasonable they are, it's going to be very, very difficult to apply to court. Now, as often applies with insolvency time limits, the court often has a general discretion to extend the time limit. They might have a discretion to extend the time limit beyond 18 months. But you'd have to have a really good case for doing so, because if you don't have a really good case, and even if they've got a discretion to extend the deadline, they wouldn't want to do so. In administrations, it can actually get quite complicated to work out which creditors have the right to set the basis. And this is because there are different rules that apply when ordinary unsecured creditors are expected to be out of the money. In other words, in cases where they're not likely to be getting a dividend. And in those cases, the creditors who make the decision are going to be the secured creditors, and depending upon the estimated outcome statement, it might be the preferential creditors as well who make the decision. And in an administration, the definition of secured creditors can be incredibly broad. It's not just the banks who've got charges registered at Companies House. It could also include creditors who've got retention of title or various other types of security as well. So that can be quite a complicated issue. Again, if you would like me to do a briefing on remuneration in liquidations or administrations, or indeed both, let me know and I can add it to the list of topics to cover in the future. So that's basically it. Those are the points that I wanted to cover this morning. If you've got any questions, then please do ask. I'll just have a look now. I don't see any that have come into either the chat box or the question box. So if you're all stunned into silence, I will say thank you all very much. I'll just mention some other dates for your diary. There's the next coffee break briefing, which is the 12th of December. And as I said, I'll be looking to cover debt financing, invoice discounting, factoring agreements, those sorts of arrangements. I've got a program of coffee break briefings lined up for next year. As long as you're still interested in turning up and hearing me give these presentations, I'll carry on giving them. Other dates are 12th of May next year, our second annual insolvency conference, and we've got a nice venue planned for that in Christchurch, overlooking the river here. I'm hoping that it'll be a pleasant sunny day on the 12th of May next year, and I hope to see many of you for that then. The third date to bring to your attention is the R3 Southern and Thames Valley Forum, which is a conference being organised in Reading for 23rd, 24th of May. And I think that looks like being a lot of fun and a good event. So I hope to see you there as well. Anyway, that's it. I'm going to wrap up now and say thank you all very much for coming along this morning. Hope to see you on the 12th of December, at least virtually, and maybe see some of you in real life before then. Thank you very much. Good morning and goodbye.